And as per open meeting laws, the chair is in fact present at the Capitol to make sure we have no concerns there. I want to start by thanking folks, the members of the committee here, as well as the public and other folks for their indulgence. This meeting was originally scheduled for last Friday. But as you know, we lost two giants within the legislature recently with the loss of Senator Dietzich and Representative Mary Murphy of Hermantown, who was the longest serving female member of the Minnesota House. And I think Lyndon Carlson only had 2 years on her in terms of the longest serving legislator in the House. So truly both treasures, and it was difficult to have services last week for them, but I want to also acknowledge that their contributions to the legislature have made it what it is. They both worked in a great bipartisan fashion and did wonderful work. So I'm grateful to have had the opportunity to attend services for both of them. And I want to thank the members and the public for their indulgence in allowing us to pay our respects to those individuals. With that, we're going to dive right into the day. Do we have quorum just yet, Mr. George? If not, we will skip over the minutes.
Madam Chair, I'm pretty sure we now have a quorum.
All right. Having reached a quorum, do we have someone who would like to approve the meeting of the minutes for December 20th, 2024? Do I have a motion?
Make that motion.
Yes.
Thank you, Member Green. Member Green moves that we approve the minutes for December 20th, 2024. All those in favor, please say aye. You may need to take yourself off mute. Sorry.
Aye.
Aye.
Aye. Those opposed, please say nay. And the ayes have it. The meeting minutes for December 20th, 2024 have been adopted. With that, I'm going to turn it over to Ms. Pollack to share today's agenda, and then we'll dive in.
Thanks, Madam Chair. All right, well, we're in the welcome and purpose section right now. We did not receive any requests for public testimony, so we'll be skipping that section, recognizing that there's a public listening session coming up this Thursday. We'll hear first from Daniel Lightfoot from the League of Minnesota Cities. He'll present and we'll do a Q&A for him, followed by a presentation by member Phaedra Howard from Helmuth and Johnson, who is stepping in for her colleague Nancy Palomas, who couldn't make the rescheduled meeting date. There will be a Q&A for member Howard, and then the majority of the rest of the time will be spent by the work group in discussion. Then we'll adjourn with a few announcements, which is first that the next public listening session is this Thursday. Note the different time. It's in the afternoon, 3 p.m. to 5 p.m. at the Burnhaven Library in Burnsville at 1101 West County Road 42. That our work group will meet next this Friday, January 10th, with an extended end time for work and recommendations. So we'll meet from 10 to 1. And then we'll also be holding 2 working sessions this month, which are not official work group meetings, but they're an opportunity to continue to finalize recommendations. And those are Friday the 17th and Friday the 24th at the regular time. For the public listening sessions, namely the one this Thursday, which will be the last one, if you're interested in testifying, please email andrew.george@lcc.mn.gov. And please note that testimony may be limited to ensure time for other testifiers, and that we invite you to submit a written version of your remarks in advance, which can be longer and which staff will distribute to working group members. Thanks.
Sorry, I'm on mute. Thank you for that. We will move on to the next part. I just want to remind members of the public who have not been with us in the past that we are here today to study the prevalence and the impact of common interest communities and homeowners associations in Minnesota, and how the existing laws regulating CICs and HOAs help homeowners and tenants to access safe and affordable housing, as well as consider what reforms to the statute may be required. And that is covered under Minnesota law Chapter 127, Article 15, Section 48. In terms of decorum, just a quick reminder to all participants that I completely understand this is a passionate topic. So we want to remind folks to speak to each other with dignity and respect and be polite at all times. Direct all comments through the chair rather than the individual asking to maintain a level of decorum. The chair will call your name and you may proceed with discussion. There may be time limits, or we may be asking to move on at times to make sure we maintain our schedule and respect everyone's time. Also, I want to note that our meeting agendas are structured to bring speakers to provide information on the things that the group is tasked with studying. With the expectation that each member of the work group will add their valuable insights and expertise into the discussion as we proceed. Also, presentation materials by any speakers and testifiers are their own. They are not the opinions of the work group. Just a friendly disclaimer on that. In terms of updates and announcements, we want to make sure to remind you there are 2 working sessions potentially scheduled for Friday, the 17th from 10 to 12 via Zoom. And the other is tentatively scheduled for Friday, January 24th from 10 to noon via Zoom. And those are working group sessions simply to review the recommendations that the work group has already put forward and sort of tie up loose ends and prepare the report that is due at the end of the month. Excuse me, anything else on that? Lastly, I will just say this before we dive into our presentations. We do not have any testifiers for public testimony today. With that said, Ms. Pollock did mention that there is a listening session coming up on Thursday. And again, just to repeat what she already said, if anyone would like to participate in that session, that you can contact Andrew George, that's andrew.george at lcc.mn.gov in order to sign up to participate. We'll also obviously accept folks who show up at that day at the Burnhaven Library in Burnsville, but please do note again that the timing is from 3 to 5. We had to find a time when the library had availability, so that is the reason for the time change, and we do encourage any members who wish to volunteer to come to those to participate. And of course, we strongly encourage legislators to come to those if they are able to hear from the general public on these topics. Finally, let's get into the presentations for today. Our first presenter today is Daniel Lightfoot from the League of Minnesota Cities. He is a senior intergovernmental relations representative and federal relations manager. There will be a question and answer period following both speakers, so we want to make sure we give them plenty of time to present. And we do want to recognize that we may need to curtail things if necessary. Hopefully it won't come to that because I know we have to get Mr. Lightfoot out the door for an appointment at 11 o'clock in the Senate. With that, Mr. Lightfoot, if you want to go ahead and state your name and affiliations for the record, and then go ahead and proceed with your presentation.
Well, thank you, Madam Chair and Chair Lucero and members of the working group. For the record, my name is Daniel Lightfoot, and as the chair mentioned, I serve as a senior intergovernmental relations representative and federal relations manager with the League of Minnesota Cities. I appreciate the opportunity to testify today and provide a high-level overview and perhaps some clarification on the city interaction and engagement with homeowners associations in the state of Minnesota. I'll also note that with me is City of Maple Grove Community Development Director Joe Hogeboom, who is here for any particular thorny technical questions that you may have on the development process Joe is a seasoned vet and is here to answer any technical questions if I need to phone a friend. I also want to shout out the league's appointee to the working group, Bloomington Community Development Director Kim Berggren, who's continues to share valuable insight on the city perspective, and of course both are a great source of knowledge for you all and can answer technical questions today. We can go on to the next slide, please.
Thank you for acknowledging Mr. Hogaboom being here today. He does great work for the city of Maple Grove. So my apologies for not mentioning that, but thank you to Joe for being here as well. All right, please proceed, Mr. Lightfoot.
Thank you, Madam Chair. I really like this slide because, on behalf of our now 841 member cities, out of the 856 cities, the league serves as the nonpartisan voice for the collective interests of all cities in the state of Minnesota. And I think it's really important to note the sort of the diversity in terms of population, especially, and of course, geographic diversity of our cities in the state. It's very important to note that when the legislature crafts legislation that has statewide impacts, understanding that legislation that impacts cities can vastly impact communities in different ways, where they are, the size of the population, et cetera. And so I really do like this slide. This does have to be updated because we now have 856 cities, but we can go on to the next slide, please. So as far as cities and homeowners associations, just want to dive into a little bit of the basics here. There's been some discussion on the working group of sort of the interaction between cities and HOAs, and I think also maybe some degree of information that needs to be clarified a little bit. So I want to provide a little bit of a higher level, understanding that I'm not an attorney, and I appreciate that Member Howard and others are going to dive in a little bit deeper of kind of the legalese of this process. But I can speak a little bit in terms of generality on the process and how cities engage and also not engage with homeowners associations. So generally in a development process, a developer will provide plans for new development within the confines of a city subdivision and zoning and land use ordinance and bring those plans to the city. But it's really important here to note that cities do not and cannot require via ordinance the establishment of an HOA as contingency of development. That is outside our Chapter 462 police powers. We do not have the authority to do that. However, cities may end up effectively enforcing requirements in statute, of which there is a very important one regarding this conversation, which is the Minnesota Common Interest Ownership Act, which is in Minnesota Statutes 515B, which provides that common interest communities shall be administered by an association, and that the association, quote, shall be incorporated no later than the date the common interest community is created. So if there is a common interest community in the creation of a development, statute leaves no choice but to establish a homeowners association. In addition to that, the plans that a developer would bring to a city now, based on primarily market factors, often now include private common area property. Generally, these decisions are driven by the market and are not generally required via ordinance by cities themselves. That said, if the plans do have a presence of private common area property, including amenities such as, pools, clubhouses, recreation facilities, sometimes private parks and playgrounds, and in some cases even, infrastructure that normally would be public and managed by a city, if those items are present in a plan, oftentimes a city will want to ensure the effective management and maintenance of that private property, because we as local governments do not manage private property. We manage, of course, public property. And so generally in that case, the developer would establish the HOA and then transfer ownership of that private property from the developer to the homeowners association. And so, as I said, during that development approval process, while we are not requiring the establishment of a homeowners association, it is in a city's best interest to ensure that that private common area property for any new subdivision, the city has a clear understanding of what is private and is managed by an entity such as an HOA, and what is the city's responsibility for that new subdivision by way of management and maintenance of the public rights of way and public infrastructure, as opposed to the private common area interests or private infrastructure. We can go to the next slide. Again, a little bit further in terms of city interaction with HOAs. I think we've heard, some conversations that cities are requiring homeowners associations to be established as a condition of development. And again, in general, cities do not mandate the establishment of homeowners associations. But as I said in the previous slide, we do seek to ensure that within a development agreement, if a development does have those private common area property and or private infrastructure in a subdivision that the developer chooses to keep private, the city would really want in that approval process to ensure that that private area and common interest property is properly managed. There have been a lot of conversations on CCNRs, or covenants, conditions, and restrictions, which are sort of the overarching kind of governance and rules documentation for a homeowners association. And we do not have any oversight over HOA covenants. We do not enforce CCNRs. We enforce city code on properties, but we do not have statutory authority to enforce homeowners association rules. Those are all outlined in the private covenants between the homeowners associations and the private property within the association. So those CCNRs are either enforced by the association itself or a management company. And because of that, this can honestly sometimes cause some headaches for cities, because generally we are the first call of, why is the city requiring me to do X, Y, or Z? And oftentimes it's not a city ordinance or requirement from a city perspective. It is a requirement within the CCNR, and sometimes those requirements can go beyond city code. We often hear about aesthetics of a building. This work group's had some discussions on outbuildings, sheds, playgrounds, etc. Even if a city issued a building permit, sometimes those CCNRs, take sort of overarching precedence because they are private covenants between the homeowner and the HOA and not the city. So we also don't enforce any type of private covenants. They're the only type of sort of covenants that a city would be a party to is if the city was a party of the covenant. So if the city owned real property, or if a city was enforcing a municipal covenant or a covenant on long-term affordability, for example, for low-income housing tax credits, which is required so that that property can maintain affordability requirements for the 15 or 30 years, depending on the tax credit. But from a private covenant standpoint between private parties, we have absolutely no authority and do not enforce private covenants in any way. I do want to mention really briefly a very cool project that has been ongoing for a number of years now, called the Just Deeds Project, in which we have 28 cities across the state that are participating in the Just Deeds Project to help homeowners discharge racially discriminatory covenants. While the Fair Housing Act made these covenants null and void, they still are riding along with certain properties. And so cities have been active with the legal community and the University of Minnesota in the Just Deeds Project to help discharge those racially based discriminatory covenants. In terms of additional city interaction with HOAs, one thing that I do want to mention, and we'll talk a little bit more about this later in the recommendations piece of this, is cities do play a really key role in supporting the improvements of common interest community, common area improvements by way of the Housing Improvement Area Statute. And this statute allows cities to allows property owners in a common interest community to petition the city to essentially front the resources for the owners of that private property for certain common area improvements. So think of roofing, siding, landscaping, roadways, parking, etc. In a common interest community, those things can be financed with the assistance of a city, an EDA, an HRA by request of 50% of the property owners. And this is a mechanism essentially because a bank would not normally, make a lending decision to, in that situation, for large capital projects with a number of different private owners. And so if owners can't get financing, the city can advance funds or issue bonds to cover improvement costs and then assesses fees back to the property owners to pay back the funds advanced or to repay bonds, which is a really important tool. We can go to the next slide, please. Just want to talk a little bit about, I kind of mentioned briefly along the lines of we often get complaints about associations that are enforcing their CC&Rs that go above city code. And oftentimes cities are blamed for these things, even though we are not the ones enforcing those requirements. And so we do know across the metro, especially in our growing communities, that cities have experienced a growing number of requests for information from residents living in homeowners associations. And some common issues that pop up are listed here. Generally the information sharing piece is really important, and I know the working group has talked a lot about this. There is some ambiguity between the associations themselves and the homeowners and who's doing what in terms of maintenance. We have generally some challenging administration, certainly in some of these HOA homeowners associations. And then, of course, this working group has talked a lot about disagreements between, fees and fines and rules, challenging rules that seem discriminatory in nature. The deferred maintenance one is really important. Having an association that doesn't have the capital reserves to do important maintenance can leave property owners in kind of a tight spot. And then, of course, renters who rent owned property in an HOA or a CIC that don't have the information for how to access individuals on the HOA, or who rent property from owners who are not current with their HOA dues, and then they get nasty grams to the residents that they're renting on something that has nothing to do with them. And then, of course, lack of governing documents, again, challenging information gathering and sharing that can sometimes be hard to access for homeowners. We do know that some cities, including Brooklyn Park and others, have continued to develop resources for residents that have included, technical assistance and data gathering to kind of understand, who is the president of the HOA, trying to get some data on best practices and technical assistance for the associations themselves, but also the residents so that they can continue to access information and not run into issues that could result in litigation. We can go to the next slide. So I want to spend just a couple of minutes on recommendations and kind of what we as cities have been looking at, and of course have been digesting in terms of the discussion of the working group. Generally, the recommendations that we would have would be to focus any legislative approach on the Homeowners Association CIC specific oversight, scope, transparency, and conflict resolution. And what does that mean? Generally, from an oversight perspective, ensuring that property owners have the adequate resources from their associations, that the role is clearly defined between the homeowners themselves and the associations or the HOA management companies. And then really think about how do we as statutorily completely eliminate any discriminatory behaviors that come by the way of rules and or fines by associations themselves. Number two, the scope piece I think is really important. generally the only vested interest from a city perspective on HOAs is to ensure that that private common area interest property is adequately managed and maintained, because we aren't doing it as cities. And that really is kind of the crux of the existence of why associations, are present in our state. And so thinking about how we focus homeowners association scope to that upkeep and maintenance of private common area property, and maybe think about how we adjust some of the things that can get a little nitpicky on individual homeowner properties. The transparency piece is really important, not just for property owners, but for cities. So improving that information sharing of those governing documents to homeowners. There's existing statute that requires this as well, of course, but there could be some additional transparencies, especially for renters of units, as well as information to the city. Oftentimes, property owners will call City Hall and say, I got to get in contact with my HOA, or I have a problem. And many cities just don't even have an idea or how to contact anybody, because a lot of that information is either not available to the local unit of government or not really available at all. And then lastly, conflict resolution. Trying to consider, is there an alternate dispute resolution method in terms of an avenue that's other than the courts, whether it's an ombudsman or another avenue that property owners could use that wouldn't result in costly civil litigation. We can go to the next slide, please. And then lastly, and this is the last slide before I take some questions, it's really important for the league and city communities to avoid any legislation that either limits or removes the ability for cities to ensure proper maintenance and management of that private common area property. Because we don't manage that private property, it's really important for us to have some mechanism that ensures to a local unit of government that property within the city boundaries, even if it's private in a new subdivision, is going to be adequately maintained, so that we can avoid doing things like nuisance code enforcement for or potentially things that become dangerous because of lack of maintenance. And then in addition to that, I talked about the housing improvement area piece, and this is really just truly an important tool where cities can help communities, common interest communities, with their improvement for common area property. There is a sunset in statute on the housing improvement area piece that will be eliminated, in that tool will need special legislation as of 2028. And so we would recommend either eliminating or extending that sunset for that important tool. And then in addition to that, consider supporting city and other efforts at the state level and the local government level to provide educational opportunities for homeowners, collecting data, et cetera. There's been some discussions on the working group of some type of database to ensure that there's information sharing on who is managing the HOA, contact information, even if that wasn't made public, making sure that local units of government have some of that information so that when we get a call from a property owner, we know who to send folks to. We can go to the next slide. And with that, Madam Chair and members, I will conclude the testimony. Always happy to continue to engage with this group. And you have, of course, an incredible resource from the city perspective in Kim Bergeron on the working group, and just appreciate the work that the working group has already done. And I'm happy to stand for questions.
Thank you, Mr. Lightfoot, for that. And then with that, I am going to move on to the next piece before we go into questions. So Member Taylor, please hold on. We'll hear from, we'll put you in queue first for after we get through the second presentation. The next is Member Howard, who is stepping in for Nancy Palomas, who was attorney at Helmuth and Johnson that was originally going to speak, but because of the date change was not able to make it. So I want to publicly say thank you to Ms. Howard for agreeing to step in a pinch. We will hear from Ms. Howard, and then we will go to questions for both of these presenters. And Member Cole, we can also make sure to get you added to the list for questions. All right.
Chair Bonner, I wonder if it might make
Yes.
sense to have questions for Mr. Lightfoot now to give him some time, and then we can switch over to Member Howard.
I was going to say we're at 10:35.
I'm fine with that.
Is that all right? Okay. All right. Then let's go ahead. We did have one member first on the list, Member Taylor, I think it was. Is that correct, Mr. George?
Yes, I believe so.
Okay. We'll do that for a little bit, and then we'll switch over to Member Howard. Member Taylor, you had a question for this testifier.
Yes, thank you, Chair Bonner. I have two questions. One, it was mentioned that cities' role is to help eliminate discriminatory rules or fines. This working group has not heard testimony, which I and Member Butler offered on the impact on people with disabilities and people of color. And my question is, how are cities proactively working to eliminate discriminatory rules in alignment with civil rights laws in the cities? Because I think that is not something I've seen our city involved in at all, and I'd love to know the process to raising those types of things in our HOAs and how cities respond to that. The other question is, you keep mentioning that you don't require HOAs by statute, but you're also saying you require someone to maintain the common area. So you are in fact requiring an HOA are there other types of assurances of maintenance that the city accepts besides an HOA? Would be my question there. What are other ways that the city would be okay that a developer could put in an agreement with the common areas being maintained besides an HOA? And are there other ways? Thank you.
Okay, I do want to mention first, we want to be very clear that when we talk about civil rights law and things like that, that is generally determined on a federal and state level. That is not the responsibility of cities. I just want to be very clear about that. But we can certainly let Mr. Lightfoot do his best, but I just want to make sure that we're very clear about that particular piece. That is generally the role
Mr.
of
Lightfoot
federal
brought
and
that
state
up, though.
government. So
Right.
I just want to be clear about that, so we don't that it might be difficult for Mr. Lightfoot to answer that from a city perspective simply because that is not their role. So I just want
He
to
brought that up as their role, though, so I'd love to have clarification on that.
so I just want to be fair about that to our presenter. Mr. Lightfoot, if you want to go ahead, I think the first part was what ways that the city might be able to contribute to that process. And then the second, of course, if there were other acceptable arrangements for handling property management of those common areas. Mr. Lightfoot.
Madam Chair, Member Taylor, really appreciate the question. And just to clarify, I brought that up in the recommendation piece, and so that is an area, as Chair Bonner mentioned, that the legislature could consider some further protections via statute. Of course, upholding federal ADA law and civil rights laws in a city is an important goal and role for a city. However, our hands are somewhat tied in terms of private covenants between private property owners and their homeowners associations that may be private agreements that cities don't enforce. And so my mention of that piece is that we do see some of those things having the effect of being discriminatory. And the legislature and this working group could look into potentially some legislation that would address those things. But again, we have very little authority, as the chair mentioned. Those adherence to those statutes, both state and federal, is generally a state and federal role. And if those things are happening, that would certainly be something for the Attorney General's office.
Thank you,
And then
Mr.
go ahead.
I also do want to make brief mention that for members on here, our next meeting is on the 10th, and the specific topic of that meeting is actually to talk about affordability as well as civil rights, human rights, and folks with disabilities. So just to be clear on this particular section, I just also want to make sure that we queue up that conversation is scheduled for Friday. Mr. Lightfoot, if you want to go ahead and answer part 2.
Thank you, Madam Chair, and Member Taylor. Again, part 2 is a great question, and certainly we'd be interested in working with the working group to see if there is another avenue. Member Bergeron and I have spoken about this a couple of times. I am not aware, and perhaps I can phone a friend to my colleague, Mr. Hogeboom. I am not currently aware of another mechanism in statutes that would allow the sort of the private maintenance of property in another mechanism. However, I'm not a developer or community development director. I think the general practice, if a developer has plans that include private common areas, that is almost always maintained by a homeowners association. There could be an arrangement where I have seen where a city could enter into contract with potentially a neighborhood, but then those entities would then become public because the city would be maintaining it. But Madam Chair, if I may, perhaps phone a friend to Mr. Hogeboom who might be able to shed a little more light on that one.
Absolutely. Mr. Hogeboom?
Thank you, Madam Chair and Member Taylor. I can really only speak from Maple Grove's experience. We, for the most part, discourage privately owned and held properties in new development projects. We like to make sure that streets are public, parks are public, trails are public, all those types of amenities are public. Where we typically see the private ownership come into play is on things like outlots or just sort of unusual pieces of property that really just don't fit any other type of use. And so really those are the only times that we see for new developments that come in where we'll have homeowners associations that would be responsible for the maintenance and upkeep of those particular pieces of property. If it is something that is a public benefit, let's say a stormwater pond or something to that effect, we would almost always try to acquire that for ourselves and have that be public. If that's not feasible, we would at least get some sort of easement agreement over that so that we would have the rights to maintain. So in Maple Grove's practice, we're always looking at ways that we would be in control of that infrastructure.
Thank you, Mr. Hogeboom. Excellent answer. I appreciate that. And I'm always glad to hear that Maple Grove is actively trying to seek those opportunities out. With that, we're going to go to the next person on the list, a Member Daly. Member Daly, I think you're on mute.
I was, sorry, thank you.
All right.
So I'm wondering, Mr. Lightfoot, about, so you had said that, so cities never have the ability to sort of require an HOA, but I'm wondering, just because we've heard a lot about the really high numbers of new developments being in HOAs, and so it makes me wonder if, basically sort of contrary to what Mr. Hogeboom said, but if lots of municipalities sort of have a tendency not to permit new development, if it does put an additional burden on the city or the municipality. Because I'm wondering about like why are HOAs like making all these roads private if they could make them public? I mean, it seems like it would benefit the HOA to spread that around to the municipality as a whole. So why are we seeing so many new HOAs and, creation of these private roads when we really theoretically don't need that?
Mr. Lightfoot.
Thank you, Madam Chair and Member Daly. It's a great question, and one that I think is sometimes a vexing one. I do think that a lot of the uptick in HOA creation is just market driven in terms of how development is happening in new, primarily single family owner occupied subdivisions in which a developer may choose to have certain amenities that are often desired by prospective new homeowners in new subdivisions, which often are in the form of private common area property, which again would predominantly necessitate a homeowners association. That said, on the road piece, I think um, in an attempt for a city to get to yes on a new development, a city may try to work with a developer to allow for deviation from a city zoning and land use ordinance or subdivision approval, which could mean that. If it was a townhome and the townhome development was off of a collector road, that the city would allow the construction of a road potentially that was either narrower or in some way, shape, or form different than normally what a city would require in ordinance. But in turn, because it does not adhere to city ordinance, the city would defer maintenance to the road being a private road. But again, I mean, the uptick in associations, I think, from what I've heard, and I'm only speaking anecdotally, I don't know, individual kind of cases and development. A lot of that is kind of how development is happening today, especially in the single family owner occupied realm.
If I may, Mr. Lightfoot, take a point of personal privilege. I understand what you're saying, but I just want to ask a clarifying question, if I may, and I'll maybe this is the same as Member Daly may have, but every city has a sense of planning for the future, right? They generally have 5, 10, 15-year plans. Part of that process is talking about things like housing, right? And particularly a mix of housing to meet the needs of their residents. So that could be anything from senior housing to address those folks who may be wanting to downsize out of their home and turn over to new families and move into a single level arrangement or something like that and not have to do maintenance. That could include a mix of low income or affordable housing with higher end housing and so forth. And as a part of that plan, what we've seen is we know from testimony here that 82% of new housing sales are happening in an HOA. And is it not in the best interest of the city to make sure that we have a mix of housing options, which means that, and we know that sometimes HOAs are not the most affordable option. And so I'm just curious, you said that the city doesn't really do that, but is it not the cities who are deciding what mix of housing options are out there? And why would they approve all of the new developments if they were only allowing for shared property and HOAs rather than some other means? I'm just trying to understand what that would look like.
Madam Chair, it's a great question, and I appreciate the inquiry. I do think that 80. I'd have to look further, but I thought that 82% number is new single family owner occupied subdivisions, because generally with multifamily rental housing, there would never be a presence of a homeowners association because those individuals don't own that property. That said, the short answer is yes. I mean, cities absolutely, especially in the 7-county metro area, but even outside of it, have comprehensive plans that is a long-range planning document that governs sort of how a city is going to grow and develop and account for infrastructure needed to support new development and density. And that also guides how cities zone and guide land for new development. And so, I think if a city zoned and guided land for a new single family subdivision of owner occupied homes, which is what we sorely need in this state, absolutely. those decisions of what the developer is trying to get across the finish line, is important to the city, of course. And I think generally, from what I've seen, a lot of those decisions from a developer standpoint to have private common area property in those single family subdivisions has become kind of the norm. And I don't know, I think cities really want new development. And so again, I'd love to continue to work with this working group on alternatives. The only thing that we are really interested in is if that new development has private common area property, that some entity is maintaining it. But we're not, to my knowledge, predicating new developments in ordinance on the existence of a homeowners association.
You, and my apologies for the privilege there, Member Daly. Did that adequately address your concern, or did you have a follow-up on that?
I just asked one clarifying question. So you said by ordinance, but my question is more sort of like by practice. I mean, are you aware of cities that in Minnesota that sort of as a practice will refuse to permit new development if it burdens them with new street upkeep, sewer upkeep, whatever? I mean, I'm just wondering if that becomes like a practice in cities. I mean, I've read about that in other states, like, oh, they won't even approve this unless it's an HOA because the city doesn't want to be burdened with the expense of, the new public property that could be part of a new development.
Madam Chair, Member Daly, again, it's a great question. And I think, Minnesota is actually, as you look at other states, is from the pervasiveness of homeowners associations is actually, I think, pretty low on the list. We don't have gated communities. Generally, we have fewer associations than our partners in other states. That said, I am not aware of common practice of cities, predicating development or refusing development based on the prevalence of an association. I think the most common practice that I've heard is if those plans include some degree of private common area property, that it is in the city's best interest and is common practice to ensure that private common area property is maintained and adequately managed, because we as local units of government are not managing that. But I certainly can do a little more digging. And I have heard that sort of anecdotal piece be discussed in the working group here, but not to my knowledge, and that would not be something that us as an organization would be recommending, certainly.
All right, thank you for that. I do want to make sure we get on to time to get to the other member questions, because I know you are running out of time, Mr. Lightfoot. I also want to say, just for a point of clarification, I do appreciate that Maple Grove actually does a good job of trying to get a mix of housing. So that is not a criticism. So I just want to be clear on that. We have Vice Chair Lucero, then we have Member Cole. And let me just double check my list just to see who's out. So please try to keep your comments brief. But we have Vice Chair Lucero, Member Cole, then I believe Member Butler, and it looks like Member Taylor might have an additional question if we can get to it. But we'll try to be as quick as possible.
Yeah, and Madam Chair, I apologize. I do have to run in about 2 minutes.
Yep. Vice Chair Lucero, can you go next?
Okay, I'll make this very fast. Elements of my several questions have been asked in various forms. The first one is, thank you, Mr. Lightfoot, for taking the time to join us. I sincerely do look forward to the continued conversations on this topic and other local municipality topics as the session gets started here. The first question I had is, do you know what percentage of new developments are being approved as PUDs? Do you have any metrics on that?
Madam Chair, Chair Lucero, I do not. Of course, the plan unit development is an important tool for developers to deviate from base zoning ordinance for new development, but I wouldn't be able to even have a guesstimate on that. But I can certainly look into that more for you, Chair Lucero.
Okay, thank you. And Madam Chair.
Vice Chair Lucero.
Thank you, Madam Chair. And so, yeah, we have heard the approximate 80% number of new development or construction occurring is being put into an HOA. And I completely agree. If there are common ownership elements, obviously they need to be managed. And I'm not inherently opposed to an HOA to manage those. But as others have alluded to, I have heard uh, from multiple sources that there are municipalities that, while it might not be in statute, it is a practice that they are conditioning the approval of a PUD on having the existence of solid elements that then necessitate an HOA. So my question for you is, since you said that you weren't aware of anything, from your standpoint, would you be resistant then if the cities don't have statute and it's not a practice that you're aware of? Would there be any concern if this work group were to have a recommendation along the lines of municipalities cannot condition approval or new construction on elements that do necessitate an HOA?
Madam Chair, Chair Lucero, I certainly appreciate the question, and you had a piece of legislation last session to this effect that you and I discussed, and I think I'd want to continue the conversation on that piece and really understand the implications without talking to members and really understanding sort of what's common practice, what's not, what's hearsay, and what's not. I wouldn't be able to come down one way or another on that. I do think that, from a league perspective, ensuring that regardless of the legislative approach of this working group, that we continue to maintain some ability for cities to ensure that that private common area property is maintained in some way. We're going to continue to have conversations on the plan unit development, and I imagine that will be a part of it. But I wouldn't be able to definitively say that without having conversations with some of our members in terms of what that should look like and potential implications. I'm not saying yes or no, of course, but I'm just trying to to kind of get a better sense. But I certainly will continue to have conversations, and I'd love to continue to work with you and the working group and Madam Chair on that piece as well.
Yes.
Perfect. Thank you so much, Mr. Lightfoot. Yeah, we'll continue that. And thank you, Madam Chair.
Appreciate that.
Thank you, Mr. Lightfoot. Thank you, Vice Chair. Now, I just want to be clear. I'm so sorry. I know we have to let you go, Mr. Lightfoot. We do still have 3 individuals that had questions. Because we have to let you go, here's my ask. We have Member Cole, Member Butler, and Member Taylor that all have questions. Would it be acceptable if we could get those questions to you in writing and then follow up with the committee members on those questions?
Madam Chair, absolutely. You and Chair Lucero and Andrew and others have my email. Of course, I'm happy to continue to have the conversation and answer any questions that I can via email.
Yeah, I want to thank everyone for the robust discussion thus far, and I'm sorry that we have this time constraint that we can't continue it because I think there have been some excellent questions asked. So with that, Mr. Lightfoot, I am going to let you go, and we will collect those questions from Member Cole, Member Butler, and Member Taylor, and we will get those over to you so that you can review them and get back to us with an answer in writing.
I appreciate that, Madam Chair. Thank you, members. Thank you, Chair Lucero, and thank you for the time. Happy to continue working with this group as the conversation continues.
All right. Thank you for that. And again, my apologies that we ran short on time in this discussion, but so here's what I would propose is that we will move on to the next speaker, Member Howard, and then we will go ahead and follow up with discussion with Member Howard. And we will make sure to get those questions from the members that you have. Please jot them down so you remember them and get those to Mr. George or Ms. Pollock, and we can then get those to Mr. Lightfoot to get those answered and make sure that you get a response since we ran short on time. With that, I'm going to go ahead and move to Member Howard for the next piece. And again, thank you for stepping in at a moment's notice to help out with fill this void since we weren't able to have Miss Palomas here today. Member Howard.
Thank you, Madam Chair. I do want to just provide a disclaimer. Unlike my colleague who was supposed to present, I do not do a lot of work with developers in creating associations. So my perspective is primarily from existing associations and how they interact with municipalities and some of the concerns that we've seen from that respect. So if we want to move to the next slide, again, my name is Phaedra Howard. I'm an attorney with Helmuth and Johnson. I've been with the firm here for almost, I think this week will be 17 years. I represent primarily homeowners associations. I also do occasionally represent some homeowners in associations that are having issues with their associations. So I think a lot of the things that I wanted to cover are very similar to what we just heard from Mr. Lightfoot, maybe a slightly different perspective. So just, basic introduction, and we've kind of talked about this already. There are obviously benefits to both the municipalities and the developers in creating properties in an association, largely because doing it through a PUD or that sort of thing allows for a higher density of owner-occupied homes than you might find with traditional zoning. And obviously developers can make more money when they can build and sell more homes on the same property. I do believe that cities, if they do not, require, they certainly encourage developers to create associations for a lot of the reasons that we've talked about, both to maintain the private property and to take that burden off of the city to manage those areas. I think one thing that's important to note is that unlike a city who might be managing public property, largely cities hopefully are employing people that have experience with dealing with budgets and contracts and all of those sorts of things. Now, when that falls onto the private homeowners association, we don't necessarily have homeowners that are on the board that have that same experience. So we've got usually very well-meaning members that are stepping up to volunteer to serve on their board. They try to do their best, but we can't expect them to be experts in all things relating to the governance of that association, which is why, of course, we encourage them to rely on outside expertise of attorneys, accountants, property managers, and other professionals. But that does cost money, and so that needs to be understood that that's going to factor into the cost of operating the association. So if we want to move to the next slide. So like Mr. Lightfoot talked about, there is some level of oversight of cities in the development process. The cities will enter into a development agreement with the developer. But the things like he mentioned that the cities are concerned about are, the number and placement of homes. How are we going to run the utilities, the other infrastructure, if there's any kind of parks or green space dedication, which we certainly have seen in the past, cities requiring that sort of thing. They don't typically get into ensuring that the construction itself meets industry standards. The cities don't oversee any drafting of the governing documents to make sure that they comply with state law. To my knowledge, cities don't get involved with, looking at things such as topography and soil conditions to make sure that they support the proposed housing. I've got several associations that I'm working with now that never should have been built. They're basically built in a valley, and there's no place for water to drain to. And so now they've got, drainage issues and that sort of thing. So I wish cities would get more involved in that piece of it, but they don't typically. So as a result, then the homeowners, again, led by the volunteer board members who are homeowners themselves, are then left to deal with things like the construction defects, drainage or erosion issues, poorly drafted documents that, really don't provide a good basis for them to even understand how they're supposed to be managing the association. And on top of that, we do see a lot of developers that also fail to properly fund the association's operating and reserves. And then they keep the assessments artificially low to sell units. So, oh, look, our assessments are only so much per month. which sounds great to a buyer until they realize that that's not sufficient to really pay for all of the things that the association needs to be paying for. And we also see, a lot of developers putting into their governing documents caps on raising assessments. So that keeps those assessments artificially low and keeps the association in a poor financial condition. We've also run into situations. I've got one that kind of surprised me up in Crow Wing County, where the county doesn't even require building permits or inspections for new development. They just, you do what you want, and I mean, they address things such as sewage and that kind of thing, making sure that they comply with wastewater and sewage treatment and those things, but they don't get into requiring those building permits or inspections. And so there's really, really no oversight in some cities for even basic construction. Next slide. Oh, we can stay on this. The other flip side of that is that we also see, for example, a homeowner wants to make a change to their property. And they may go to the city for a building permit without ever having gone through the process to get that approval from their association. And cities will just issue a building permit. They don't get involved in determining whether or not the homeowner even owns the property that they want to do the work on. A lot of times, the homeowner's lot is platted very close to the building footprint and is surrounded by common areas, and they may not understand that they don't own the property where they want to, put up a shed or extend a deck or whatever. Cities don't typically get involved in that. They don't look at whether the proposed work is consistent with the governing documents or even allowed under them, or whether the homeowner has gone through whatever approval process is necessary with the association to get the association approval. So the cities will, again, issue building permits, and homeowners go and do work that has not been approved by the association. And there really doesn't seem to be any consistency in my experience from city to city or county to county on how these matters are handled. So next, going on to, okay, now that the association is constructed, it's here. Other than, making sure that there is an association in place okay, now it's the association is responsible for maintaining those common areas. I don't see anything from municipalities actually providing ongoing support to make sure that that happens and to make sure that those associations are successful. So it's okay, there's an association, we're out of it, we're done. And I'm not necessarily advocating that they need to get involved, but that's the reality that we live in. Other things that we see are, cities are doing work maybe next adjacent to, so it's public construction project, but adjacent to property. The cities don't have to give a whole lot of notice to those property owners of proposed construction. And even if it could impact the association for things like access, parking. I've run into several situations where we've had damage to association property. Unlike Maple Grove, not every city takes ownership of those stormwater retention ponds. I have an association who has one on their property that was damaged by the widening of a street, and they were left with about an $800,000 bill to repair the wall in their retention pond, and the city would not acknowledge or take responsibility for having contributed to that in any way. And it's really hard for anybody to bring claims against the city because there's a level of immunity for many types of claims. Another issue that we see in a lot of areas are the police just frankly refusing to respond to calls within an association. Prior to the decriminalization of cannabis, we would get tons of calls, oh, my neighbor's smoking marijuana in their unit and it's, really bothering me. You call the police, they won't even come out in many cities, most cities that I've heard from my clients. or other things that they say, oh, the association should deal with that. And it's not necessarily an association issue if it's criminal behavior. Now we've got the under the cannabis law, it now prohibits smoking of cannabis within multifamily buildings. And again, we're seeing the same thing. Police don't want to enforce that law and don't want to get involved. And so that really leaves associations in a tough spot because they do not have the same police powers. They can't enforce, just like the cities, when Mr. Lightfoot was saying the cities, aren't going to get involved in enforcing the covenants on association property, but the associations can't enforce state and local ordinance on their property either. So there's sometimes this disconnect where, the police say, no, the association should be handling it, and the association really doesn't have authority to, because they, their authority essentially to enforce covenants is to fine an owner. That doesn't necessarily stop violations. It doesn't address criminal behavior. So associations are often left, in my opinion, kind of floundering to try to figure out some way to address these things when local authorities are not willing to lend support. Next slide. So we've heard some talk in this group about, what really is the function of an association. And I just wanted to clarify, they are corporations, typically formed under the nonprofit corporations law or potentially the cooperative corporation law for cooperatives. But they're corporations, so they're subject to corporate law, not municipal law. And that doesn't mean we can't look to some, municipal law for guidance, but they're not subject to it. They are corporations. The members are shareholders. And so they have the same rights and responsibilities as any other corporation. Again, of course, we have additional regulations through the Minnesota Common Interest Ownership Act that does create additional obligations and rights of both the associations and the members that aren't in the corporate statutes, but that's really no different than any other industry that might be subject to additional regulations beyond just the corporate statutes. So again, the associations don't have police powers to address anything that might be state or local law. They only have fining powers. Possibly some don't even have that to enforce the governing documents and rules. The association doesn't receive any public funding, so they rely entirely on the assessments paid by the members to fund their operations. Some associations might have, some rental income from a commercial tenant or something like that to supplement, but primarily the income comes from those assessments to the owners. And associations really try to budget tightly. Their goal is to have a zero balance budget. So, exactly what we think we need to operate, that's what we're going to assess to our owners. So if owners don't pay their assessments or things come in over budget, over what they anticipated, that really puts associations in a difficult position. And then that's when we look to, okay, do we have to levy a special assessment? Do we have to, get a loan to cover a shortfall? Or do we have to defer maintenance and some of those things that Mr. Lightfoot was talking about? And this kind of perpetuates itself in a lot of respects because associations, if they don't have money to pay for things and, maybe their documents require approval of the owners to increase the assessments over a certain amount or to levy special assessments, if the owners don't approve that, there's really no other option. They have to cut costs. And in my written materials, I also included a large document talking about the insurance crisis. I would recommend everybody take a look at that because I think it's really, we've heard about it, but it really has had a very significant impact on association funding and overall financial health. Associations can't get the funds to pay for the insurance, then they have to look at other options. Not only does that result in reduced coverage, putting more of it on the homeowners, but again, we've had associations that have had no other choice but to cut services, defer maintenance, and that sort of thing because all of their budget is going to insurance. And so that, and then when we have deferred maintenance, that again affects the ability to get insurance in the future. It affects the ability of owners to sell their properties and that kind of thing. The other thing I wanted to touch on with the public and private streets is we've run into situations where I've got one association, smaller association, they have basically homes on two streets. One is a private street that's owned by the association, the other one is a public street. And what ends up happening is all of the owners in the association have to pay to maintain the private street. But if the public street needs work and the city assesses those properties on that street, now those owners are paying for double because they're having to pay for the improvements to the public road that they live on, as well as pay to maintain the association's private streets. So we have run into situations where cities recognize that and will say, you know, we will agree to assess those costs to the association rather than to those individual property owners so that the association can then divide amongst everybody and level the playing field. But to my knowledge, there's nothing out there that requires a city to do that. And so we're still running into issues where, you know, some owners are paying double essentially. Next slide. So Mr. Lightfoot already talked about the housing improvement areas. I agree with him. This is an awesome option for associations to utilize. Again, he mentioned that it sunsets. The other issue is that it's absolutely optional for cities to participate. And so we have some cities that have done a lot of these. St. Louis Park, Plymouth, I know are some that have done a lot of HIA projects, and it really helps those associations do work dealing with structural issues, deferred maintenance, those kinds of things that they might not be able to pay for any other way if they can't get a traditional loan or those sorts of things. But there's some cities that just haven't done them, don't want to do them, don't want to figure out how to do them. And so, I mean, associations in those cities are really kind of stuck. Like this would be an awesome option, but the city won't do it. And so my recommendation would be not just to get rid of the sunset, but also find some way to either require cities or certain size cities to participate, or have some other process where an association can petition to somebody else to get the city to participate. Because again, this feeds into the whole issue of deferred maintenance, insurance. If we can't get funds to fix our buildings, we can't get insurance. We get blacklisted from Fannie Mae and Freddie Mac, who won't finance loans for people to buy into the association. And so our owners can't sell. And so they're stuck there with properties that aren't being properly maintained because we don't have the money to maintain them. Next slide. And so my recommendations are somewhat similar to Mr. Lightfoot. Again, I would like to see some more consistency across the state and how cities and counties are dealing with things like permitting and inspections, the emergency and police response, the street assessments that we talked about, and participating in the HIA program. I would also like to see some requirement by the cities of developers to address or more thoroughly address, you know, getting engineering studies and that sort of thing to address things like drainage, runoff, erosion, and those kinds of things, where we're making sure that when a developer creates this community and builds it in this place, that it's not only going to be a successful community, but it's also not going to have a negative impact on surrounding properties. I would like cities to require some sort of proof of compliance by a homeowner with the association's process for getting approval before they issue a building permit to that homeowner. And with regard to the insurance and being able to pay for things, I would like to see a legislative workaround to allow associations to levy some sort of emergency assessments without owner approval if their documents require it. I know, for example, California has a by statute has a cap on increasing assessments above a certain level without owner approval, whereas we don't have it legislatively, but it's in a lot of association documents. But they also have a legislative workaround where certain situations, the association can levy an emergency special assessment to pay for certain things under certain circumstances. So I would like to see something like that created here to allow associations to get around those restrictions in their governing documents, in order to levy assessments to be able to pay for maintenance and insurance and those kinds of things. Next slide. So that's all I have, was just on my presentation, but I'm certainly open to questions.
Okay. Thank you, Member Howard, for that. Do we have members with questions? If we do not, I think I may have some.
Chair Bonner, we do have a few hands raised.
Wonderful. Member Cole, it looks like is first in queue.
Thank you. I appreciate that. You talked about the insurance coverage, which is a particular issue, but the insurance coverage should be covering the properties. We have a lot of instances where the management company worms their way into our insurance policies, so we are covering their risk and their liability. What do you recommend that we do, or what could be put in place to make sure that management companies have their own insurance and that we're not paying for the liability of the management companies? And yeah, that's my main question there.
Okay, Member Howard.
Thank you, Chair Bonner and Member Cole. What I see in my practice is that because the management company is taking on the role of acting as the agent for the association, the management company does typically require the association to cover the management company for claims that might be raised against the management company in their capacity as agent for the association. And I think that makes absolute sense. But the management companies also maintain their own insurance as well. So I don't know that there's much additional increased cost to the association to add the management company as an additional insured on their own policies. But management companies would not manage associations if there weren't some protections for somebody thinks that I made this decision, but it was really the board, and now you're going to sue the management company, which is not even the correct party. So of course they need some protections in place for that, but I don't think there's much extra cost to the associations to simply add the management company as an additional insured on the policies.
I have an insurance policy from an association in Brooklyn Park where they have workers' comp on their policy, and that's not okay. And yet, but to your point, the management company should be a contractor, and contractors, by virtue of anything they do, carry their own insurance. Plus, in our CCRs say that the management company needs to carry their own insurance. Doesn't matter how much cost it adds to the policy, it's about the risk to the homeowners. And if the management company, in my opinion, doesn't want to take the risk of managing it, then don't. It's your choice to be hired, and in a lot of cases where I have seen where they have kind of kicked in the door and taken over, but they're still a separate company, and Minnesota law also says management companies are supposed to be a neutral third party. So how can you be a neutral third party if you are on somebody else's insurance policy?
All right. Thank you, Member Cole. I don't know if there was a question there or a comment.
Oh, yeah, a little of both. How can you be a neutral third party if you are on somebody else's insurance policy?
Member
And
Howard.
how do you support the law when the law says you are supposed to be a neutral third party? And why isn't the board, I mean, they're hiring a contractor in theory, but they're not functioning as a contractor. How does that make it okay?
Right. Thank you, Member Cole. Member Howard, I will give you an opportunity. I know that's maybe I'm not sure, that might be a little challenging to answer, but I will let you do your best.
Thank you, Chair Bonner. I would first say I'm not aware of any law that says a management company is required to be a neutral third party. So I'm not sure where that piece is coming from. The management company is, typically hired by the association, which acts through the duly elected board of directors. So while they manage the full association in the best interest of the association, they do act through the direction of the board. As far as liability, like I mentioned, the management companies all have their own insurance coverage that covers them for things that they do. And their actions. The additional insurance is in order to protect them from claims that are improperly made against the management company based on their acting at the direction of the board of directors. So claims that really should be directed to the association or the board, but are directed or added parties, add the association or the management company or the individual managers as parties when they are merely carrying out the direction of the board. So they are requesting the associations to carry additional insurance to make sure that if that happens where somebody improperly names them as a party based on them simply acting as the agent, that there is coverage by the association to take care of that.
Workers' comp isn't part of that though, and in our case, the management company has appointed the board. Our board chair has never been on the ballot. So it's not as straightforward as what you are talking about. And I know our management company has a long history of wherever they're at, that they do appoint board members, and none of our board members have been appointed, have been voted in. There is no evidence of that. And I also know our board chair has never been on the ballot. So it's not as simplistic and as straightforward as what you're presenting, because the board in that case works for the management company. The management company doesn't work for the board. So thank you.
All right, thank you, Member Cole. I do also want to remind folks to remember to go through the chair first to make sure we maintain decorum. With that said, it sounds like there may be a recommendation coming around the workers' comp piece that maybe we should explore coming from Member Cole. But we'll get to that. Member Taylor, you had a question for this speaker?
Yes, thank you, Chair Bonner. Hold on just a second. Let me pull up where I have it written. A couple questions and comments. One question is around, and I'm very happy that Member Howard that you mentioned cooperatives. Is there any, this was kind of with my question for the last speaker, is there any reason that that cities aren't working with developers to recommend cooperatives as an option for maintenance? When I ask the question, what are other options? It's odd to me that that doesn't come up as an alternative. So do you have any experience with that would be my first question.
Howard.
Thank you, Madam Chair and Member Taylor. Cooperatives are a form of common interest community. So it would be no different. They have to be managed by a homeowners association. The main difference with cooperatives is typically the members don't own any real estate, and so the association owns everything, and so it's kind of a hybrid between a ownership interest and a landlord-tenant relationship. But I don't think cities push for any particular type of community association. Cooperatives are, in my experience, the least understood by all parties involved. So I don't think that they're pushing any particular type, certainly not cooperatives. A lot of the cooperatives are also using HUD insured financing, so there's oversight by HUD on that. Whereas, I mean, that's not the municipality, that's HUD. But there is some oversight on that respect if they've got HUD insured financing, which many of them do.
Yeah, I would say a key difference as well is that cooperatives have collective governance and collective decision making in a way that traditional HOAs do not, with having a board leadership. There is a board, but there is more member input and more collective governance structure within a cooperative. And I think that is very appealing to a lot of people because that's what they kind of expect when they're going into an HOA. And they often find that that is not the way things are actually run in terms of how decision making happens with their buildings. I also wanted to know,
Member Taylor, just a reminder, you need to go through the chair and wait to
I
be
don't know
called
what
on.
that means. I'm just speaking.
Okay, that means that if Member Howard is done and you have an additional question, then I would go back to ask you if you have any additional follow-up, and then you can proceed with additional questions.
Okay,
So,
sure.
Member Taylor, did you have any follow-up or an additional question?
Sure. I love the recommendation around around not sunsetting the loans. I don't think most HOAs know about that. I recommend that that would be moved to MHFA, who is very adept at doing these types of loans. And it would be then available at a statewide level. And then, okay, do I need to wait now?
Is that the question?
Um, No, it's a comment. When do we get to have discussion as a working group? I'm sorry. I'm very confused.
So, right now we are asking questions of the presenters based on their presentations. We will then move into the recommendation phase, and we will talk about any potential recommendations and a discussion around those recommendations in the
Okay.
next portion of the agenda.
Then I'll hold. The question was around the cooperatives. Thank you.
Thank you. All right. Thank you, Member Taylor. Do we have any additional questions from the folks? I did want to ask one last question as long as we have Member Howard here. There's been a lot of conversation about the sunset under Minnesota Statute 428A point 11. Could you just briefly, Member Howard, talk about that and what that sunset entails and what it does and how that impacts municipalities and homeowners associations?
Certainly. Thank you, Chair Bonner. So the sunset, the existing program for the housing improvement area loans and financing is set by state statute, but it's set up in a way, like I mentioned, that makes it optional for cities to participate in it. Once that sunset happens, which is June 30th, 2028, I believe, after that point, cities will not be able to participate in it in any new ones. They can finish up any that have already been approved, essentially, but they cannot designate any new properties as housing improvement areas for purpose of the financing after that date, unless there's specific state legislation that authorizes that. So this is a program. It's been extended a few times. I think I can't remember when it first went into effect, but it was like a 2-year program, and then it's been extended, I think, at least 1 or 2 times since that. But it was kind of a trial program, and then it was extended. But if it doesn't get extended again, then it would not be an option that would be available to anybody in any municipality after that date.
And just for point of clarification, Member Howard, what we're talking about is the ability of cities to provide sort of a low interest financing for the update or improvement of properties, including HOAs, which may have that. And I know there was a conversation that we don't often, that it's rare that associations go to cities to seek that. And if I'm understanding correctly, and please do correct me if I am mistaken, right now, what happens is if you have an improvement in the city, so for example, we need to replace a road in front of your house. Generally, the city will send you an assessment for what the replacement of that road is going to be. And they allow you, I believe, two options, if I'm not mistaken. One is that you can pay that assessment up front and just pay for it off the books in advance, or you have the option to potentially add that to your property tax and pay it over time, like an extended period, say 10, 20 years. I'm not sure what the parameters are on that exactly. I might be off on that, but it basically allows for a more affordable option for a homeowner to make those, to help pay for their fair share of that assessment, but do it in a way that's reasonable and that allows them to do so over time, right? Whereas what we see often with associations when they finance on their own is that the assessments have to be done and there's sort of a compressed timeline. And it's very difficult for homeowners often to get a loan to cover those assessments, or sometimes their insurance won't cover it all or will only cover a part, even though they should have insurance to cover that. Sometimes it doesn't. And so if I understand this correctly, is what we're asking is that rather than doing it, associations doing it alone and trying to figure out how to finance that what they might be able to do is go to the city and ask them for a similar arrangement to what they do for every other homeowner, right? That if it's going to cost $10,000 or there's an $8,000 assessment to fix your road, we're going to say the city could then arrange some sort of low interest financing for those homeowners and say you either have the choice to pay it up front or we add it to your bill over time. Is that a correct assessment of how that program works?
Chair Bonner, yes, it is. There's several ways that they can do that. They can sell bonds or different ways, but for the property owner, it essentially gets paid back through the property taxes. So it's an added assessment to their property taxes, which is benefiting the associations and the owners really in two ways. One, again, extending the time period to be able to pay, but also because it's done through the property taxes. Typically, a homeowner, if they're selling their unit, would not have to prepay the remaining balance of that assessment at closing in order to sell. So the new owner would just pick up paying that through the property taxes, whereas any other kind of assessment from the association, a lender would typically require that to be paid up in full at closing so that there's no lien carrying over from the association that could impact the property.
Thank you for that. And one last clarifying question. We also mentioned that it is very rare that associations are seeking out that mechanism for funding. And I know this is a little bit speculative to ask, but do you, and again, I'm asking an opinion here. I know that you may not have exact figures or can't speak for cities, so I want to be clear on that. But do you have any thoughts on why more property or associations and boards aren't perhaps seeking that mechanism to cover basic things like replacement of a road or something of that nature? I'm just curious if you have any insight into why associations and boards might not be seeking that more frequently.
Thank you, Chair Bonner. That's a good question. I think a lot of it has to do with the timing. The whole process of getting it approved is very lengthy and takes a lot of time. So, I mean, they have to work with, their board or whoever to figure out what is going to be the scope of our repairs, usually getting, bids from contractors to get an idea of that. And then there has to be a homeowner vote to approve the scope of repairs. I have one association right now that is trying to do that. I think it's through the city of Plymouth. And the homeowners did not approve the full scope of repair. So they have to go back and revise that scope and then do it all over again to just get the process started. So it's very, very lengthy and very involved, and not a lot of boards or managers even understand what's involved. There are consultants out there that I can think of one that everybody uses, like, okay, we're doing HIA project, use this person to help you go through the process. But if you don't know about that, and I don't think it's widely published, and again, not all cities are doing them. So it's not even an option for every association to even go to their city and say, will you do this? We had a situation with one of my clients down in Rochester where they had some major structural issues a year and a half ago. Building came very close to collapsing, and they're trying to figure out how to pay for structural repairs. HIA was not an option because Rochester doesn't do them. So they had to go get a private loan.
Okay. So it sounds like some of the barriers are that some of the cities just don't do HIA funding, as well as some of the barriers might be around timing for approvals. And of course, some of the complexities around the homeowner voting and approval of scope and things like that might be some of the barriers that are maybe limiting the use of that tool for cities who do offer it. But I appreciate that insight. And just as a point of clarification before we move on in our meeting today, you mentioned there was a resource that often deals with these particular issues, and I would love to have a conversation with them about how that works and what that mechanism looks like in a little more detail. So if you could pass along that information, that would be lovely. I would love to have a conversation about that part too. That said, I do not see any other hands. Before we move on to discussion and recommendations, do we have any other members that have a question specifically for Ms. Howard before we move on? If not, we are going to go ahead and push forward. We actually had a pretty robust conversation about that, but I do want to get to a little bit of conversation about potential recommendations. Do we have anyone who wants to start with conversations about that? I know, Member Cole, you might have had something on the specifically on the piece around the workers' comp. Is that fair, Member Cole?
Well, it's making us pay for any kind of liability insurance for the management company. And also around the municipality piece of that, he kind of hedged around how it's really the developer's fault things are this way, but the municipality has to sign off on the developer application. So making it clear that the municipality is putting something or requiring the developer to have sane, sound business practices in the CCR that go beyond just managing the land. It's about how the association is run, and that part is missing from the municipality.
So I'm hearing, I think, two different things. The first
Right.
is around insurance liability for the property management companies, and specifically perhaps prohibiting the workers' comp piece. We'd have to look into whether or not the other piece, but it sounds like there may be various reasons why they have those arrangements to cover the decisions by boards if those property managers are simply acting on the direction of the board. And it sounds like that might be the reasoning behind that portion. So that sounds like the first recommendation. And the second recommendation, if I hear you correctly, is that we are talking about municipalities not requiring specific elements that would require the necessitation of creating an HOA. Is that an accurate depiction?
Yeah.
Okay. So maybe, Ms. Howard, we want to split those, or whoever is writing them down, into a separate item there, which is basically saying that the municipality cannot require elements of shared property that would necessitate an HOA. Although I think based on what I've heard, the law already sort of leans that direction, but I think that is what we're asking. And perhaps maybe there's a way to clarify that better in terms of what's actually happening in practice versus what the law says. Member Kimball, you had your hand raised with a potential recommendation.
Yes. I'd like to recommend what Mr. Lightfoot was framing around making it so that HOAs have a focus on common area maintenance and common property only, and eliminating the inclusion and enforcement of declarations. I think one of the things that's been highlighted throughout our conversation is that the personal property enforcement that HOAs do can sometimes result in discrimination or result in foreclosure, because there has to be the provision to allow for enforcement of declarations that exist or fines that exist. And I think that the reason for an HOA to exist should be limited to simply managing the common property that's held by the HOA.
Okay. I'm not sure the city has a role in that particular piece, but I understand what you're saying. And I think we've probably been talking about that in a different way when we talk about handling issues around fines and fees and what are sort of the parameters, what things are spelled out in governing documents and things like that. But appreciate that, Member Kimball. Member Taylor, you had a recommendation.
Yes. I have one. Hold on, I'm looking through my list. One was about having the housing improvement area loans move to MHFA. They have more infrastructure to do this type of loan. And they do it for developers, they do it for homeowners, etc. So they could do it for HOA homeowners or homeowners associations, I would think. Around the recommendation for creating a loophole by Member Howard for assessing in emergency situations. Creating loopholes is never a great idea in my experience working in housing justice, so I would just say it needs to be extremely narrow. I don't think it's a bad idea to have a workaround. I think it just needs to be extremely, extremely narrow. I also, hold on. I think there needs, and I don't know exactly.
Pardon me for one moment. When just to be sure, we want to say for emergency. Yes, thank you.
Thank you.
All right, thank you. Sorry, Ms. Taylor, or Member
Yep.
Taylor.
That's okay. I think that HOAs need to be required, or cities need to be required to collect board member information and contact information and property management information annually, so that residents can get that information from the cities, or it could be required to be posted by the HOAs. The issue with that is that homeowner boards probably won't necessarily know the law. They don't know most of the laws in my experience. So, and then the
Member Taylor, just as
final,
a clarification on that
sure.
question, I think when we had discussed earlier about licensing and registration through the Secretary of State,
Mhm.
there was a recommendation that requested that that information be disclosed
Great.
through the Secretary of State rather than through a city. Is that, are you suggesting that it should be both? Or are you suggesting that
I
just
mean,
trying to look for an alternative.
I would say as a homeowner, I would not know to go to the Secretary of State before my city. But I really don't have a preference. I would just say that all of these things are going to be, I would think about it from a homeowner perspective. Who would you call first? Would you call the Secretary of State or would you call your city to find out this information? And that's probably where the law should go. And then, so yeah, maybe it can be both. I'm not sure, how legislators want to work with that. But
Yeah. Although
and then
perhaps if, just to be
yeah, go ahead.
clarify, if we do not require that information today, is my understanding. But if
Right.
we did, then cities would at the very least know where they
Where to
could go
get
and
it.
find that information
Yeah,
in
sure.
one place. So I just wanted to ask that clarification.
Yeah.
Okay, thank you. And
I
you had
think
one
that's
additional
great. Yep.
recommendation?
The last thing is something, and I don't have clear thought around it, but around funding or education to cities and the public around cooperative ownership models. I think that they're very, very underutilized. I think that they're very beneficial and they would satisfy that maintenance requirement. Um, and I think they would also solve some of the issues that homeowners have around transparency, accountability, not having voice in their associations, etc. Um, and then the last thing was actually about what member Kimball was discussing. I just want to endorse that as well. It's really, in my experience, where a lot of problems arise because, for instance, my covenants say stuff like there's no recreation on our grass or in our parking lot. So there's no recreation in our property that can happen, which is very, it has a huge impact on people with children that might want to live here, right? Which is a protected group and under fair housing. So you can't have kids that would want to play on the grass or play in the parking lot of our private property. But that's an allowed covenant. Nobody's allowed to have a picnic or play a football game or do anything. So it's just stuff like that that tends to have really discriminatory impacts on protected groups. That certain demographics of people, in my experience, tend to think are okay, but they're not okay. So just wanna put an asterisk on that I
Yeah.
agree with that.
I'm not sure the cities have much impact over that specifically, although I appreciate where you're going, that seems like an unreasonable request of an HOA.
Right.
You can't expect children not to play, for example. That would be pretty odd, right? It is kind of the nature of children that they tend to like to play out and they like to play outside sometimes. So
Yeah, nobody's allowed outside at our property to do anything recreational. So
yeah.
maybe that's my recommendation is we take out that or we ban that.
So perhaps the recommendation is that there is a prohibition to HOAs that they cannot require that that their members use common areas as common areas, which
Right.
sounds a little bit strange, but yes.
Yeah.
Okay.
I like that because yeah, we are paying for our grass to be mowed, but we can't go use the grass. We are paying for our parking lot to be maintained, but we can't rollerblade in our parking lot, for instance.
Yeah, that they can't use common areas as common areas is really what we're saying. Okay.
Right.
All right, very good. Member Green.
Thank you, Madam Chair. Back to the HIAs. I know that those have definitely saved associations in when they're really in a tight spot. And so I think it makes total sense to make them available to more associations and have that be statewide. I'm definitely in favor of that. I have a lot of questions about the HIAs. I don't know if they're different in each municipality. I do know just from experience with seeing some buildings, and I'm talking condo buildings, that have utilized them in a time of need. I mean, it was definitely what saved their building, but there was no payoff option after the initial, the initial deployment of this financing. So for example, there's a building that has, values that have really plummeted, and in a large part because they show this assessment on taxes that you can't pay off. Where, I would think in a normal transaction, some sellers over time would choose to pay that off completely and remove that obligation from future owners. So I guess there's a lot of questions there on, could possibly there be a payoff possibility for people in the future. I think that would help support the real estate values in those buildings that are affected. Then this building I'm talking about, there's no payoff, and it extends through 2037, and the values are depressed. So in protecting property values, could there be some option there with terms?
Yeah, so I hear two things there. The first is that we see uneven enforcement of cities being offering the HIA as an option. And I think what you're asking here is that we create something in statute that requires all cities to offer HIA as an option, whereas some cities currently do not. If that's number one.
Yes.
And then the second, if I heard it correctly, was that if we do go through the HIA process should allow for a payoff before the end of the term, if a homeowner so desires. So just because they put it on their property tax doesn't mean that they're bound to just paying a little bit for the next 20 years, that they have the ability to A, pay up front, B, pay over time, or C, to pay that off in its entirely early.
Correct.
Is that correct?
Exactly. Thank you.
Okay, thank you. All right, I appreciate that. Member Howard.
Thank you, Chair Bonner. I have to leave for another meeting in a couple minutes, but I wanted to make sure that some of my recommendations for my presentation got on here before I left. So again, I agree with Member Green about requiring all cities to offer the HIA loans. I would also reiterate my recommendation that sunset either be pushed out or eliminated, so it's a eternally available option instead of a temporary one. And then again, my recommendation that that there be a legislative workaround for those emergency special assessments to pay for insurance or necessary repairs or those sorts of things.
Yep. And I think so, first of all, and thank you for that, because I was actually just about to bring that one up, that we should either extend or eliminate. Sorry, we're talking too fast. So the recommendation is to extend or eliminate the sunset under section 428A.11, correct?
Correct. I think it's actually in 21.21, not 11, but.
Oh, okay. Well, 428A, we'll just go there. Possibly 0.21. That sun is set to set on June 30th of 2028. So either extend or eliminate that. And then I'm sorry, your next recommendation was sorry, I lost track.
Yeah, so the other one was what Member Taylor was talking about from my presentation is authorizing a legislative emergency special assessment that would not require homeowner approval, even if the governing documents otherwise require homeowner approval for assessments for certain emergencies.
Okay, but we would probably, I know they said a narrow definition, which in other words, we would have to set parameters around what would constitute an emergency.
Correct. Mm-hmm.
And what the parameters of that would look like, to ensure that we are doing our best to cover homeowners' right to have a say, but also when there is a legitimate emergency, that we're both not amusing that emergency, but we're also allowing for it.
Correct.
Correct? Okay.
Yes,
All right.
thank you.
Thank you for
And
that.
with that, I do have to hop off to another meeting, so thank you.
Thank you, Member Howard. Member Berggren.
I think that the stuff I was gonna say just got covered, so I was wanting to affirm the idea of removing the sunset and the HIA loans have been, in my experience working in cities, I worked in Brooklyn Park for almost 2 decades, and they did about 1 to 2 HIAs a year. And so I would just caution us from removing the abilities for cities to do it, like was suggested on one of the lines. But certainly if cities don't have capacity, having it available at the state makes sense.
So possibly what the recommendation is to allow the option for both city administered HIA options and MHFA.
Yeah, that makes sense.
As opposed to only one, the option to use both of those as options.
That's what
am
I
I
would say,
understanding
yeah.
correctly?
Just maximize the system's capacity. Yeah, and then extending, or I think removing the sunset makes sense. That's a great tool that's been shown to be really effective to the extent that it's been used. Although it is very cumbersome, I agree with that but I also think some of the cumbersome steps are also needed to make sure that the homeowners have access to information.
Yes. All right. Great. Thank you for that. And then I just wanted to call out also, there was a recommendation around greater communication to renters and how that could benefit cities because that is not always happening now. So it might be a potential improvement both for homeowners, for renters, and for associations to have greater communication with the renters. There was also a suggestion around municipalities providing greater information to homeowners adjacent to new developments to talk about things like access and parking and so forth, and some mechanism to perhaps report concerns around those issues. Seem fair? If I'm hopefully covering that correctly. Some of the other recommendations from Mr. Lightfoot are actually in line with things that we have already covered. Except for one, he did mention that we may want to clarify in statute the role between homeowners, homeowner associations, property managers, and the city or county. So that was homeowners, homeowners associations, property managers, and cities and counties. And I'm not sure what that would look like, but I kind of heard that from his member Taylor. You had one in addition?
Just one more comment on the one around the on the recommendation around management companies and paying for their insurance. I know it's been said a number of times that they're just acting on what the board asks them to do. But that's not just the role of management companies. They're often directing the board and then getting a final okay from the board. But the board often doesn't know what to do and is giving most of the decision-making power to management companies or most of the directive power to management companies. And then they're making final decisions based on those strong recommendations. So I do think it is not accurate to say that they're just acting on behalf of the board. And so in terms of considering those types of recommendations, I just wanted to make that clarification.
Okay, thank you. There was also a recommendation that came forward, and I don't know exactly how to word this. So if somebody has thoughts, please feel free to jump in. But they were talking about permitting and not permitting something unless an HOA approves of the project first, although I'm not sure that's perhaps an appropriate relationship. But we may want to explore a recommendation around the permitting process, and perhaps that associations should honor that permitting process if it is legally within the bounds of or the city's process, that HOA should not be refusing perhaps something that is permitted as legal. And I think that came up specifically around a shed. I think we heard a story that was created within the confines of their aesthetic mandates. A permit was issued, and the HOA then demanded that they remove the legally permitted shed because they didn't like it. I don't even know how to phrase that. They didn't. I'm not really sure, but I think that was part of that came forward. Member Cole, did you have one?
Yes, making sure that the decisions are justifiable. I know there's been a talk about reasonableness. Well, reasonableness can be anything across the board, but they need to be able to justify their decisions. And yes, I do know the story about the shed, and there was no reason for they didn't have to justify their response to her about making sure that the shed didn't happen. This was a disabled homeowner who wanted the shed so she could store a riding mower so she could take care of her property. And there wasn't anything in the bylaws that prevented it. The city approved it, and yet, and this kind of relates to the what you were getting at over the approval from the architectural committee. Well, who on a board is going to know enough about architecture to approve it? There needs to be some sort of third party review of what is okay and what not. But in her case, the shed was on her property. It didn't conflict with any of the other properties, and yet they felt justified in threatening her, and they even fined her for filing a fair housing complaint over the shed because they weren't convinced she is disabled. Now, that's not justifiable, that's not reasonable, but yet the city says they can't get involved in stuff like that.
So if I heard you correctly, there is one thing that you're recommending is that we because we discussed the other part already, but that associations may not assess a fine for filing a fair housing complaint.
Right.
Is that accurate?
Right.
And we're about to start losing staff, so I just want to make sure that we're being conscientious of that. I did also want to call out, there were 2 points that were made. One was a recommendation around that we did the one about the adjacent communities, but one was about greater clarification of the roles and responsibilities around things like retention ponds. And whose responsibility that is under the law. And so we may want to include that. And the other was that we would want to make a clarification around that HOA or builders may need to be required to do impact assessments to assess issues like proper water drainage, runoff, and soil erosion around their properties. I think I heard that one as well. So we may want to add that as a recommendation as well. And I think those are the last of the ones that I heard. Is there any other last comments or recommendations before we get ready to adjourn? Member Taylor.
I just have a question. I'm going to be out for medical leave for the 17th and 24th. Can I get a copy of the recommendations to make comments on them that I can send prior to that?
I can talk with staff about what that might look like. we can talk about that.
Okay. Thank you.
Yep. The only hesitation I have is that that's a living, breathing document and it's constantly changing and evolving. And so I'm not saying we shouldn't try to get you the information. I'm just saying that whatever we send you could be rapidly changing and evolving and may not.
Right. I just don't want to try to rack my brain to make recommendations that have already been made. So being
Okay.
able to comment on things
Yeah.
that you guys have those notes, because I just won't be able to have input on the final recommendations otherwise.
Sure. And just so folks are aware that there is some grooming that will be happening here to try to combine where we might have duplicates in the recommendations. So I just wanted to make folks aware that we are trying to do a little cleanup in those recommendations to make it easier to walk through them and discuss those recommendations. So hopefully that will help a little bit, Member Taylor. All right, Senator Pye, you had a last comment before we head out?
Yes, I thank you, Chair Bonner. I just wanted to say that oftentimes in these meetings, I write down 2 or 3 things that come up that I go like, okay, this is great. I'm going to write this down later. I'm going to contribute this or say this is one of the recommendations I really like. And by the time I hear from all the members here, it's like they've covered it. I just want to let all of you know just how incredibly grateful I am to be amongst all the members here in this group because you come up with things that I haven't even thought about. You often say the things that I've thought about and said, okay, this is something that's great. So I just thank you to everybody for the great work that they do. And Chair, I just want to emphasize that a lot of the recommendations on here, I absolutely agree with as we move into the new session and think about things that we're going to be doing this legislation. I'm looking forward to a lot of these recommendations becoming a part of a bill. Thank you.
Thank you for that. And I will tell you, just for public edification here, I want to remind people before we go that there is a public listening session for this Thursday at the Burnhaven Library. The address for that is 1101 West County Road 42 in Burnsville. And that meeting is scheduled again for January 9th, this Thursday from 3 to 5. Sorry, it's a little earlier in the day, but that was based on availability. So I want to make sure of that. I also want to remind us that we have working sessions happening on potentially, these are penciled in for your calendar for you to be able to manage that on the 17th from 10 to 12 via Zoom and on the 24th from 10 to 12 via Zoom. That is just to kind of review recommendations and report pieces and sort of make sure we can kind of clean that up and have a report ready for the legislature. I also want to make sure that I am very crisp about this, that we have seen some really strong themes emerging during the course of our conversation here. And we actually have had several bills that cover some pieces of recommendations. So that gives me a hope that we are on the right track. But I would expect that we will very likely have a large bill that encompasses all of our recommendations and reforms. And we will also very likely have the separate bills from that larger bill that will be worked through committee because we know that working a bill through committee takes a lot of work and effort and input from many, many stakeholders. So I would expect that we will very likely see in the new session a number of bills on these issues cropping up. So just wanted to clarify that as well. And I expect that all of our members, Republican, Democrat, Senate, House, will all be involved in that process and working through those issues together. I anticipate that we will have some good bipartisan work to be done on this issue in particular. And with that, we have no other business before the committee. So I am going to call this session to a close and we will see you on Friday. Thank you, members.